Welcome to our Rapid Fire Wednesday Q&A for corporate immigration professionals. I'm Kimberley Robidoux, a partner in our San Diego office, and I am joined today with Miki Matrician, who is the co-managing partner of our WR Immigration Boston office. Hello to you, Miki. How are you?
Hey, Kim. How are you?
Good.
So for today's installment of Rapid Fire Wednesdays, we want to cover multinational managers as another way to avoid the PERM labor certification process. So I'll provide a little background quickly. So as we covered in previous episodes, the PERM labor certification is the first step in the three-part green card process. And it's a quite expensive and time-intensive process for employers. And then the other piece of the puzzle is that the Department of Labor, which is the government agency that processes PERM labor certification applications, is taking longer and longer to adjudicate. And so the multinational manager green card case waives the requirement for the PERM test of the labor market. And that means it's a good way for employers to bypass the Department of Labor. And anytime we can do that is a cost-effective and efficient way to get your most senior employees a green card. And so, Kimberly, do you factor those in and anything else when you are advising clients as to whether or not to pursue the multinational manager case?
Yeah, Miki, definitely. Those are the factors that we look at. And there are other factors as well. One of the biggest is the fact that the multinational manager classification, a lot of times referred to as EB1C, falls under EB1, which is employment-based first preference category. So typically with our EB1 category, there are no backlogs. And that has been the case for a really long time. However, recently there have been backlogs for individuals who are born in India or mainland China, but they're still not as significant with respect to the backlogs as EB2 and EB3 are for individuals born in India or mainland China. So it definitely is a benefit to look at.
Yeah, and there are also, processing advantages too now that's available for multinational managers if your employee is eligible. It's eligible for premium processing at USCIS, which it didn't used to be an option before, but it now is in the last recent months. And basically, under premium processing, USCIS will adjudicate within 45 business days, which is basically, 9 weeks or a little over 2 months. And that's a good option because under regular processing, it takes 9 to 10 plus months. So let's now turn to the criteria. Kimberly, can you tell us what the criteria are for the foreign national?
Yeah, sure. So the employee must have a job offer by the petitioning employer, and the job offer has to be in a position that is primarily managerial or executive. In addition, the employee must have been employed outside of the U.S. entity by a related entity or where there's a qualifying relationship. And that employment abroad has to be for at least 1 year within the 3 years prior to being transferred to the United States. So that year abroad also has to have been in a position that is managerial or executive level capacity. So that key point is absolutely critical.
Totally, that's right. And then in terms of requirements for the US employer, there are criteria too. The employer has to have been doing business in the US for at least 1 year before the petition is filed under this category. And then both the US entity and the foreign entity must show that they're both continuing to do business for at least 1 year. And the US employer and the entity abroad must continue to maintain a qualifying relationship as recognized under the regulations. So, when we say qualifying relationship, it means that the US entity and the foreign entity has to be either parent and subsidiary or affiliates. What does that mean? It means both entities are subsidiaries that are owned by the same parent company or entities that are owned and controlled by the same group of people that own about the same portion of each company, or a branch office situation where the petitioning employer is the US company and the branch is abroad. The corporate relationship part of the multinational manager case can get really complicated, and we're happy to help advise in these situations. And then the other criteria is that the US employer must show that it has the ability to pay the employee's salary through financial documentation. So things like the SEC Form 10K if it's a publicly traded company, or US corporate tax returns or audited financials. So now let's talk a little bit about how you go about advising your clients, Kimberly, about who might be eligible for this type of case.
Yeah, sure, Mickey. So when, talking with our HR professionals and the individuals as well, if somebody is employed in a C-suite level, then, in most instances, the company is going to start the green card process for that individual, almost immediately after they have come to the United States in some type of non-immigrant classification, right? The L1, with the exception of a new office, right? If somebody is coming for a new office, then there's whole other criteria that we need to look at. But for the most part, C-suite level employees, are treated with the option to do the green card process almost immediately. And then for other managerial or executive level positions, we usually look at what the company's immigration policy is. So is there some type of time limitation with respect to, when the green card process can be started? So some companies will say after you've been in the US for 6 months or after you've been in the US for 12 months. So that's something that is definitely, we would look at what that company's immigration policy is. And if they don't have one, help them create one to see if they want to do something that's consistent moving forward. So the other, thing that we're looking at is that more often, the profile of these individuals who are being sponsored for the EB1 multinational manager classification are in the United States in L1A status, right? L1A is for managers or executives. So they're in the US performing that managerial or executive level role. But not all L1As are eligible for the green card multinational manager, because to get an L1A classification in the United States, the employee could have held a specialized knowledge position abroad and not a managerial or executive level role. So there's a little bit of a, thing that we need to look at from that perspective.
Yeah, I think that's an excellent point, a really important one, because, if the person was in an individual contributor role outside of the United States, even if they are a manager now, they won't be eligible for this multinational manager category. And I think it's a fairly common misconception among HR professionals. And I think it really highlights the point that Immigration Council needs to work with HR or global mobility to ensure that the role abroad was primarily managerial or executive in nature. And I say primarily because just because somebody has a managerial or executive sounding title, it doesn't mean they qualify for this green card category. And I think I'll just pause here and just take a few moments to go over what the managerial criteria are. And it's number one, that they must manage the organization or department, subdivision or function or some component of the company. They must, number two, manage a department or subdivision, but it could also be a function that they manage if they don't have direct reports. They must operate at a senior level with respect to that entity or department or the function they're managing. And then also, they have to exercise discretion in a day to day operations of the activity. Or again, if it's the function they're managing, the day to day operations of that function.
All right. So, those are all really good points. I'm glad you went over the criteria, just so everybody kind of has that in the back of their mind of what, is evaluated for the position. So the role abroad also must meet those criteria, right? And not just the US role. So to qualify as an executive, the employee must direct the management of the organization or a major component or function. The individual must establish goals and policies. The individual must also exercise wide latitude and discretionary decision-making, and then also receive only general supervision or direction from higher level executives or the board of directors or shareholders. So those are some things that, immigration attorneys will evaluate in determining whether or not this multinational manager category is a possibility. So I have another common misconception for you, Miki. It's kind of the reverse of what you mentioned, right? So the misconception is someone who is in the United States in L1B status may not be eligible for multinational manager classification. So can you explain that?
Yeah. So we do see that from time to time. The company transferee may have been initially coming to the US in a non managerial or non executive role, but rather in a more specialized knowledge or individual contributor capacity. And then, the 1 year abroad could have been in a managerial or executive capacity, but when the initial L1 was done, it was for, the US role being specialized knowledge. And so they didn't qualify for an L1A as a manager. Basically, in that kind of case, the initial L1B case would have argued that the employee had specialized knowledge, even if they were in a managerial or executive capacity. That case would have really shown a spotlight on the specialized knowledge aspects of the role. And then once the employee is promoted to a managerial or executive role in the US, then they could have been changed over to an L1A visa status. But even if they were not changed over to L1A visa status, it's worth looking at somebody in L1B visa status to make sure that the role abroad was not limited to specialized knowledge, but maybe they were in a managerial or executive role. It's just that for the L1B case, the case was deliberately strategized as highlighting just the specialized knowledge capacity of that role abroad.
Yeah, absolutely. It's worth digging deeper before starting a perm process for someone like that. It will help save time as well as cost and resources for the company. And it also makes, our HR partners and especially the foreign nationals incredibly happy if we're able to dig in and say, guess what? We can avoid perm. We're going to go right to multinational manager. So it really takes looking at the whole history of the case. And it might even take gathering additional information, as you mentioned, Miki, to find out more about what the position overseas entailed, right? To kind of get those nuggets for the managerial capacity. So one of the other things that we wanted to highlight today is that, when there's a change in the corporate organization and a significant change, meaning that there's a situation where the company or the entity at which the L1 individual was working abroad no longer exists, right? The operations were closed down. Maybe the company is still there in name only, but there are no longer any operations. So it's not, engaging in any kind of business or commerce. So when those entities are closed abroad, don't get caught in the trap, right? We need to be really wary of that and make sure that we're looking at it from the whole perspective. So the L1 classification is slightly different than the multinational manager for the EB1. And that's based on some slightly different language in the law. And so from that perspective, while an individual can continue to maintain L1 status in the United States, even if the company at which they were employed abroad closes down or ceases operations, they're able to continue in that L1 capacity as long as there's another entity abroad that has a qualifying relationship with the US company. So the L1 is preserved, great. But if that specific entity no longer exists abroad, then the individual is not eligible for the EB1 multinational manager permanent resident process. And that's a real shame when that happens. But it's something that, we definitely want to discuss and look into, because there's nothing worse than getting, almost all the way through the I-140 EB1 petition only to realize that you can't go any further and you have to backtrack and do a perm case. So it really is something to keep in mind, is what has happened to the office abroad where that individual was employed.
Yeah, and just to add there, Kimberly, that, for HR professionals and global mobility professionals, as much notice as Immigration Council can have in terms of any plans of office closures outside of the United States, and of course within the United States too, but any information in advance would help Immigration Council to help advise and plan for what kind of green card category can be pursued and set the employee's expectation.
Yeah, it's a really good point, Miki, because the perm process takes way longer. And so there's a lot of preparation that goes into that well in advance of the maximum for L1 status. All right. So that is the multinational manager permanent resident case and common caveats in a nutshell. So join us next week for our discussion about name, image, likeness. What does this mean for foreign student athletes? And we're going to be interviewing our partner, Cliff Rosenthal. So join us next week for Rapid Fire Wednesday. Cliff has a lot of experience on this topic, so we're excited to pick his brain on that. Right. So if you don't already, please follow us on our LinkedIn page for WR Immigration, as well as Miki and my individual profiles. And then we also transcribe this Rapid Fire Wednesday into a weekly newsletter that you can subscribe to. And the information to subscribe will be in the comments. So until next week, have a great, wonderful day.
Thanks, Kim.